The judge in an NFL player's rape trial questions a jury member about what they heard through the grapevine about the case.
We would ask that you excuse this juror.
As emotional witnesses take the stand to recount what the victim told them the night of the alleged crime.
She said that Josh raped her.
Our legal analysts take a deep dive into what we learned from the Ohio courtroom. Law&Crime Daily, covering court cases from coast to coast. Welcome, everybody, to Law&Crime Daily. I'm Jesse Weber. Witnesses who were nearby the night a woman says a professional football player raped her testified in an Ohio courtroom about what the victim revealed right after the alleged crime. Josh Sills, an offensive lineman with the Philadelphia Eagles, was indicted earlier this year on one count of rape and another count of kidnapping. The victim, sometimes referred to during the trial as MM, told police in 2019 that Sills was giving her and her cousin a ride home after a night out. The victim said that she'd known Sills for several years and they even went to high school together. She told police that when her cousin got out, Sills pulled her back into the truck with him and forced her to perform oral sex before eventually letting her go. Sills and his defense team say that that sex was consensual. The victim testified Tuesday about what happened to her, but chose not to have her voice or image recorded on camera. On Wednesday, one of the friends who was out with the group that night was emotional as she described what MM told her when she got inside the house.
She said that Josh raped her.
Okay, who was she referring to?
Josh Sills.
And he was the individual that was with you guys that night?
Yes. She said when I pulled up in the driveway, he held her down on him, on his penis, and she couldn't breathe. And she tried hard to fight back. And she said that he tried to unzip her pants and physically, sexually assault her the other way vaginally, but she got away. She said she had some strength that came over top of her, and she got out of the truck. And then she showed me the marks from where his hands was holding her down on her legs, on her inner thighs.
Okay, let me bring in my legal analyst and co-host, Brian Buckmeyer, Terry Austin. Terry, I'll start with you. You know, it's one thing for the victim to testify. It's another thing for someone else to testify about what the victim told her. How impactful is that testimony?
She was very impactful. She cried. She seemed very credible to me. And the best part about her testimony, as far as the victim is concerned, is everything happened at the same time on that night. She learned of the rape the day it happened, the alleged rape, obviously. So I think this is very different from other cases. This is a case where it's not just he said, she said. This is a case where you have a witness who's there the same night and who is testifying on behalf of the victim. I think that is going to go far as this jury is concerned.
If they can show the injuries, Brian, match up to her account, is that a conviction right there?
I think it is. That's corroboration. It's not just an issue of, is this victim credible, or this alleged victim credible? Is the good friend that she outcried to also credible? But now you have one story, two story, and physical evidence to corroborate it. I think it's very hard for Sills to get up there and argue anything else. The question being, why does she have these injuries, and why are they proven if this was consensual sex?
And I know there's always that allegation of rough sex gone bad. I mean, we'll see if that's where they go. He says it was consensual. What's an outcry witness? Because we were just referring to that.
An outcry witness is someone who's coming out and saying, you know, exactly what happened. This is the person who is the victim's friend who's coming out and saying exactly what she saw that night. She's an eyewitness to what exactly happened. One of the things that I think about this case is the defense is definitely going to try to claim that this was consensual, but I think also the defense is claiming that Bing, the witness here, was, you know, drinking along with everyone else. Bing was underage, but saying that the victim was someone who was drinking.
Does this mean he has to take the stand?
I think he does. I mean, who else is going to be able to get up on the stand and say this was consensual other than the two people inside of the car? And I don't think it's going to be the alleged victim. I think it's got to be Sills.
And so it really does become a he said, she said in this kind of case. Difficult. These cases are always so difficult. And a lot of times it really does come down to who the jury believes in terms of the testimony. And still ahead on Law&Crime Daily, court was on hold in the Sills trial this morning as the judge addressed a juror issue. What the juror heard the night before that could have an impact on her judgment, and what the judge ultimately decided to do. That's next.
Law&Crime Network is searching the country for the best detective in the United States. We're looking for the top investigators who help to solve the nation's most high-profile cases, from medical examiners to forensic experts or even private eyes. If you or someone you know believes they're one of America's greatest detectives, submit your applications now. The top 3 detectives will be featured on our social media, and the winner given a $5,000 prize. Go to lawandcrime.com/detective to submit your nomination.
And welcome back to Law&Crime Daily, everybody. We are continuing our coverage of Josh Sills' rape trial out in Ohio. Early Wednesday morning, the court spent around 15 minutes dealing with a very serious jury issue. You see, one of the jurors contacted a bailiff, letting the court know that she had a phone call from a friend who had overheard defense attorneys talking while they were out to dinner Tuesday night. Now, while the defense thought the judge should replace her with an alternate, the prosecution was fine with keeping her on. The juror explained to the judge and lawyers how she was contacted.
A friend of mine had called me, and she works at the Forum, and she was telling me that the defense counsel had went to the Forum for dinner and were talking about her friend's case loud enough that the other employees could hear them talking, and they knew who they were talking about, and all the coworkers were upset. And I said, I can't talk about the case, I'm on the jury. And she said, okay.
We would ask that you excuse this juror for the fact that she has received information outside of the testimony in this case, that she has learned that the folks at the restaurant were offended by our conversations, as well as that information she provided, which would be part of perhaps an argument as to the circumstances surrounding the assault. So I think that that's a serious enough of series of events that would warrant her, in order to protect the jury itself, to have an alternate sit in her place.
Under oath, she indicated that this didn't impact her opinion on the case or the evidence she's reviewed so far.
So I find, based on her responses, that the request to excuse her as a juror should be denied. She'll remain as a juror.
All right, Brian, what do you think? Juror saying she received a phone call about the attorneys talking, is that too prejudicial? The juror shouldn't be seated anymore?
I didn't like necessarily the defense's argument. I think they could have gone a little bit harder on the idea that this juror got a phone call that aggravated at least her friend, that the kids go out together, they hang out together, so much so that they called her and let her know. It's not about information outside of the case, it's about how she feels about us now. If I, as a defense attorney, have now tainted this case to the point that my client can't get a fair trial, you've got to let her go. And I think as an appellate court might lean that way and toss this case out, where it otherwise seems pretty strong for the prosecution.
That's the defense's argument. That's the defense attorney and Brian Buckmeyer. What do you think, Terry?
Well, you know,
Did the judge make the right decision in the end?
I have mixed feelings. I at first thought she should be tossed, but I think the judge did make the right decision. Listen, the defense should not have been in that restaurant speaking so loudly that everyone in the restaurant could hear what they were saying. And frankly, it's a small community, and they should have understood that someone at that restaurant might know one of the jurors, and in fact, they knew the person, absolutely the victim, and they didn't like the conversation, and they called the juror. And I just think that, you know, when the juror found out, she immediately contacted the judge, and she said to the person who called her, don't speak to me. So I think she did exactly what the judge asked her to do. So for those reasons, I think she could stay.
Well, let me ask you this. You said the appeal. If he gets convicted, how do you show that that incident is what prejudiced the jury to vote against Sills?
I'm asking each and every juror, except for that one juror that got the call, what was your impression of her? when someone said X about a piece of evidence and she said Y, or even X about something that
You mean, what do you think of the juror?
Yeah, of that juror.
Okay.
When someone said X about what I, the defense attorney, said and she said Y, did it always come back like it seemed she had a negative issue about me, the defense attorney, rather than the case? And by surveying the jury, if that comes positive, that's ammunition for an appeal.
Real quick, Terry, should this have been a mistrial?
I don't think, definitely
nothing
not.
like that,
Not a
right?
mistrial. She shouldn't have been bumped off. I think the judge did make the right decision. She should stay. She said she could be fair. That's the bottom line.
I think you're right. If he is convicted, that is going in the ammunition books as a potential appellate issue. Not sure it'll be successful, but definitely an argument.